In breaking news here on Legal AF, we have our first federal judge who's trying her hand at issuing an injunction to block in this case, the reorganization and defunding of the Department of Health and Human Services, which would impact hundreds of millions of people, children, adults, their health, their science, cancer prevention, childhood illnesses, pregnancy diseases and illnesses, all because Donald Trump wants to sever your relationship between you and your health, between you and your federal government, between you and the programs that you've relied upon and the states rely upon, like the Center for Disease Control, in order to protect America and their public health. We have a public health agency that couldn't care less about public health. And now we got Judge DuBose in Rhode Island, and she's stepping up. She's the youngest judge. She was just appointed about 6 months ago by Joe Biden. But she's next up. Level up, batter up. She's issuing her injunction in the wake of Friday's ruling by the United States Supreme Court that said you can't use nationwide injunctions, but left open the door. What if you have a lot of states? What if the states bring the case? Can a federal judge bring a nationwide injunction then to stop a policy or plan of Donald Trump? How else would you do it? How else would you fashion the injunction? You're here on Legal AF with Michael Popok. Take a minute, hit the free subscribe button as we continue to march and grow our pro-democracy channel. Let's get back to Judge DuBose. She sounds she writes with dripping sarcasm here, and also a fair amount of fatigue. But she knows that she is the guardrail that protects this democracy in this case. And she writes on page 2, yet another group of plaintiffs seek relief from a federal court to halt sweeping changes to a federal agency's operations, which they claim disregard congressionally mandated programs to the detriment and peril of all who live in the United States. The subject at the heart of this controversy is the Health and Human Services, the agency, the Department of Health and Human Services, and the attempt to reorganize it. See, Congress creates the agency. Congress funds the agency. The presidency is just supposed to execute, not eliminate it, not defund it, not fire everybody, not sever the relationship between the people and the agency or the state and the agencies. 19 states, Judge DuBose says on page 3, and the District of Columbia challenge HHS's implementation of its plans as a violation of the Administrative Procedures Act and the U.S. Constitution and asked for a preliminary injunction. She then attacks the challenges by the Trump administration. She says this hodgepodge of challenges will be familiar to those who are tracking the dozens of cases around the country similarly challenging the Trump administration's efforts to reduce and reorganize the federal government. She finds that the states have prevailed in their preliminary injunction requests, that they are more likely than not, they have a likelihood of success on the merits to prove that Donald Trump and Robert F. Kennedy's actions, Jr.'s actions, are arbitrary and capricious, as that term is used under the Administrative Procedures Act. There's no research. There's no analysis behind it. Even RFK Jr. admitted that he's overcutting. He's going to have to probably rehire 20% of the people that he fired, endorsing chaos. That is the definition of arbitrary and capricious action. What I found remarkable with Judge DuBose is that she reminds us of how important the Department of Health and Human Services is. She goes through and catalogs all of the groups that receive some sort of care through that agency. The Centers for Disease Control, in which she says on page 15, the states describe a symbiotic relationship between themselves and the CDC. They rely on the CDC's infectious disease laboratories for an array of services, including diagnostic testing for rare and complex diseases, susceptibility to an antibacterial resistance testing for infectious diseases, developing new diagnostic tools for sexually transmitted infections, and dealing with outbreaks. Also, pregnancy risk monitoring systems are now being put at risk by what Donald Trump has done. It's also imperils the Center for Tobacco Products about being able to enforce laws to ensure that tobacco products are not sold to minors, which relies on that. The Office of Head Start, which has been thrown into chaos, she says on page 18, and so on. At the end, she then concludes this way. She orders the parties to tell her why she's wrong. She says, this is my injunction. I think it applies to the states. I think it applies for me to declare and to enjoin, not just to declare it, declare an unconstitutional, but to recognize the harm that's being suffered by these states right now and put a stop to it with a preliminary injunction. She's basically challenging the Supreme Court to say, you say I can't do a nationwide injunction? I got 19 states in front of me. You say I can only declare the unconstitutionality or something is arbitrary and capricious? I need to protect those that are in front of me. And I'm going to enter an injunction to stop the Trump administration from taking a wrecking ball to Health and Human Services. And I want the parties to tell me in the next 2 weeks or so, if you believe this order is in compliance with the decision on Friday by the Supreme Court in a case we call CASA, or is it somehow too broad, or it's akin to a nationwide injunction. But in the meantime, you're enjoined. Here's what she's ruled on page 56. The state's motion for preliminary injunction is granted. HHS and all other defendants are enjoined from taking any actions to implement or enforce the reduction in force or restructuring. The party shall file a notice with the court by July 11th, addressing the way in which, if at all, Trump versus CASA, the case from Friday at the United States Supreme Court about injunctions, impacts the scope of this order. She then stuck it to the Trump administration. She said, I'm going to look at a bond here. You want me to have a bond posted? Here's what she says about a bond to support an injunction. The defendant suggests the bond be commensurate with the scope of the injunction and take into account that the relief requested by the states will hinder the agency's ability to reorganize pursuant to the president's policies. In the court's opinion, the states and the constituents have plenty on the line in this litigation. The court imposes a nominal bond of $100. And now we're off and running. Here's how she concludes. I'll end the hot take this way on page 58. Circling back to the separation of powers principles covered earlier in this decision. The executive branch is vested with the power and is imbued with the responsibility to faithfully execute the laws which govern the governance structure of our country. The executive branch does not have the authority to order, organize, or implement wholesale changes to the structure and function of the agencies created by Congress. As Judge Smith in this district recently warned when presented with the declining depth of civics education in public schools, quote, we may choose to survive as a country by respecting our Constitution, the laws and norms of political and civic behavior, and by educating our children on civics, the rule of law, and what it really means to be an American, and what America means, or we may ignore these things at our and their peril, citing a case, AC versus Raimondo. I mean, we just have a new poll out that says that 65% of Americans are embarrassed to be Americans. It's primarily 95% plus of Democrats, and about 70% of independents. 98% of Republicans believe that everything's going just fine, and they're proud to be Americans. There's no bigger patriot on YouTube than me. Doesn't mean I agree with anything or respect anything that this president does. And I think that's the point that we're seeing in the polling, that people are embarrassed by the policies because he has kidnapped, hijacked our United States of America and shrink wrapped it in some MAGA plastic, garbage bag that we now have to fight our way out of and through. I'll continue to follow it right here on Legal AF. Take a moment, hit the free subscribe button. Help us continue to our march to 1 million subscribers. Till my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.